Thank you, Bishop Alistair. It's such a pleasure to be here. So thanks to you, thanks to the Global Sustainability Network. I'm such an admirer of what your organization is doing and the vision that is leading it, and the platform and network you're setting up to make the vision become effective. That's very much the idea that has motivated me in my work. As you heard from Bishop Alistair, I'm David Snyder. I'm a law professor at American University. I will admit I did go to Yale, and that's actually how I first got connected with an old friend from Yale here. But I'm based in Washington, D.C., and my day job is being a law professor. And my fields are contracts and commercial law, and that includes their U.S. and their international and comparative aspects. And I always emphasize that because I'm usually a bit of a stranger in a group like this and a mix like this, because I very much come at it from the business side and the legal side. And this is a much friendlier group than I am used to talking, than I'm talking to. I talk to people, let's say, in the extractive industries in Texas and in Central Africa, and apparel manufacturers and sporting goods and pretty much everything you can imagine. And there are many priorities that they have and many needs that they need to balance. And where this work comes from is hearing from these businesses, which my colleagues and I tend to think of as clients, right? They're the clients. And what we found is they do want to do the right thing. I said this in a public gathering of a bunch of business lawyers, and I usually get nodding. The thing is, people picture businesses and they picture skyscrapers. And the thing is, the people who make the decisions are people, and they don't want to do the wrong thing. It's not like the skyscraper is deciding what to do. It's people, so they want to do the right thing. And I was making that pitch, and one of the other lawyers leaned forward and said, "Yeah, they want to do one right thing at a time." And so I think that's a piece of reality that we need to keep in mind. And this project is motivated by that picture of the world, of trying to do the right thing in a complicated world where there are many priorities and many pressures. And this tries to be a very realistic project. This is not an aspirational, oh, wouldn't it be nice if. It is, what can we help the companies do ideally right now? And the idea is take the first step and then the next step and then the next step. So being a very hard-headed, practical-minded business law kind of guy, the idea here is to use contracts as a practical method for achieving both human rights and environmental protections in international supply chains. And the key insight here, and I can talk about this more if you want, but I know this is not a crowd of lawyers, and so I'm going to stay away from the legal technicalities, but I think everybody's probably aware that there's no world legislature to effectively pass a law saying no modern slavery, and now we're going to enforce it. And there have been some efforts in that direction. I will talk a little bit about them, but they are of, let's just say, insufficient effectiveness. And one of the key legal pieces, in fact, the legal piece that holds supply chains together is contracts. And contracts are legally binding under contract law. And so if you have the same law that makes it so that there's a breach of contract if they don't deliver the goods or they deliver them late or you don't pay for the goods, the idea is, well, let's get the human rights protections and the environmental protections in there and treat them in the same way that we treat these other, what I'm going to call product values. So let's treat the non-product values like environmental and human rights protections in the same way that we treat product values. What's the key to doing that? Contracts. So this work comes out of a group that I chair, a working group of the American Bar Association Business Law section. There were efforts from the ABA to do this out of the labor section and the international section and so on. And mainly because of opposition from the business side, it didn't really go anywhere. So the president of the ABA, and there's an interesting political message in this, said, okay, business law section, you do this. And so this is, what they did was, first, they came up with this idea, okay, we want to achieve good results. What we need is good policies. What you might notice is the policies are not the same as contracts. Contracts are legally effective, and what's more important to me is that they be operationally likely. And the idea of policies is, really nice, but if you're a hard-headed business lawyer, like, those of us in this part of the ABA are, you look a little bit askance at the policies. So you can find the policies, and I don't really mean to pick on Abercrombie. It's just like, it's so fun, and it's so easy. And so you can go on their website, and they probably changed the model now, but they're incredibly attractive models, and like you can click around and find their policies, and from my standpoint, that's useless. What you need is the contracts, and the business law leaders were really good at coming up with some model policies. And because it was coming from the business law folks, and I'll talk about this more later, they were very good at getting the companies to adopt them. So up they went on the website, and everybody was smiling and patting each other on the back, and those of us closer to the ground were kind of rolling our eyes. It's like, okay, well, that's nice. Until they get into the contracts, nothing's going to happen. So I actually made the mistake of saying that publicly in the ABA, and they were like, okay, well, David, why don't you do something about that? So that's how I wound up chairing this working group. And so we got to work, and from a legal standpoint, for reasons that I think I won't get into with this group, it's very difficult. The bottom line is that commercial law, the law of contracts, and especially the law of sales of goods, and that's mainly what we're talking about, and even the law with respect to services, so goods and services, it's focused on the goods and the payment for the goods. And if you're talking about non-product values, then the law doesn't work. And I usually sum up the legal problem with one horrific phrase. Child slaves can make great soccer balls. So the soccer balls come in, they're fine. They're tainted, but like all the things that the commercial law is going to look to, it's like, well, those are conforming goods. All right, well, so we were like, we'll put in warranties against, let's say, slaves in the supply chain, child labor, and so on. So now you have a breach of warranty. Remember, we're hard-headed business lawyers. What are you going to do about that? There is no remedy, because your remedy in contract law is damages, and the soccer balls, again, are fine. And as long as they can be sold at the regular price, there are no damages. And you could say, all right, well, they can't be sold, but it's not in the interest of anybody to say they were made with forced labor in the supply chain. So the background law doesn't work, and so that's the big picture problem that we saw. And we were like, okay, from a commercial law standpoint, we need to deal with that, and we need to manage the risk that the companies are dealing with. And we came out with this first version of the model contract clauses to make them legally effective and, more importantly, operationally likely. And what most companies were doing is say, see all that stuff on the website, that's incorporated in our contracts, and so that's binding now. For the reasons I just explained, that doesn't work. They need these clauses to make them work. And we realized we were very sort of business law focused, and we reached out to labor and to consumer advocates and NGOs and so on. And they rolled their eyes at us and said, you know, you're not our people. And we got a little bit of comment, but not much. It's like, okay. And so we published them, and the businesses started using them. I wasn't sure how to track this, but the way I tracked it at first was that I didn't really track it, but we made the mistake of publishing them. I actually had to fight the ABA on this, but I insisted that they be made available free to the world on the internet. The ABA wanted to charge. So anyway, they let us do it. And then I started getting emails saying, your PDF is not converting well. Could you send us a Word version? I was like, okay, well, that's a good sign. And so they started being used. And once they started being used and they were going out to the world, now we started hearing from the NGOs, unions, labor, etc. And they had quite a lot to say about our approach. And they were supportive of the idea, but they did not like our methods at all. Well, actually, there was a bit of a mix, but there was a fair amount of criticism. And so we said, okay, well, what's your problem? And we heard they had a long list. And so we did a second version, which is really a sea change from the first version. And I'll talk about the consultations that went into it, but it's a completely different idea. It is much larger, and I know we have a Q&A session after the presentations. And you know, let me just say, I love doing these talks because I want to hear what y'all have to say. This is how I learn about, you know, what people see as working, what people see as not working, and so on. So we have this large set of contract clauses and then schedules that go with it. And the schedules, we give guidance on how to make the schedules, but the schedules are the part where you say what the standards are. Like if you're Abercrombie, you need to worry about forced labor harvesting cotton. If you're making cell phones, you don't need to worry about that. You need to worry about rare earth minerals, conflict minerals, that sort of thing. So we can't really say what goes in for each company, but we try to give some guidance. And that's actually the crucial part. So we take this completely different view from what we had done in the first version, which is the conventional way to go. So the conventional way to go is the supplier is forced to say, I promise that everything is going to be perfect in the supply chain. And if it's not, then I'll be liable because I'm warranting this. So it's a representation and warranty. And the supplier is responsible. And if they breach their contract, then they're responsible for all the contractual remedies. And because of the work we did in the first version, it actually works. And the second version changes basically everything about it. Instead of saying everything is perfect, it says both parties have to be duly diligent about human rights issues. Let's not pretend everything is perfect. If we're saying everything is perfect, then we know this isn't going to work. We have a lot of experience with this. We know it doesn't work. It's sort of like sexual harassment policies in a big company. They say, we're great, we have zero complaints. Well, that tells you the policy's not working. What we need is due diligence, priorities, and we need involvement from both the buyer side and the supplier side. And the buyer has to take responsibility for its purchasing practices. That may include paying fair prices. One of the things I learned, price is sort of obvious. One of the things that drives a lot of problems is change orders, and timing. And that leads to a lot of the illegal subcontracting and other issues that I can get into more if y'all are interested. And then instead of going to termination and contract remedies, we go to remediation. Okay, what's the problem? Let's try to fix it. Chairing this group, let me just say, is politically delicate. And there's a lot that a lot of people don't agree on. The one thing that there's general agreement on almost all the time is termination is bad for everybody. And so it's much better to remediate the problem. So that I thought was going to be controversial, but no, everybody's lined up behind that. And then to have relational dispute resolution rather than sending it into arbitration or litigation, that sort of stuff. And there's some innovative stuff there too. So that's what we try to do in our second version. I see a lot of people out there in the audience nodding. And if I were talking to a different group, I'd be hearing a lot of shifting in seats and a lot of lip biting and so on. And it's like, why? Okay, well, that sounds nice, but why? I knew it was a mistake to ask a law professor here. Why should we ever do this? And I have an answer. It's because you want your policies to be effective. And what I say to those groups is, look, and I know that you didn't really need them to be effective for years. And it just didn't matter. But that's changed for a variety of reasons, which they actually know better than I do. And I'll talk about those reasons. The other thing that I say to them, and I know, if you ask for guaranteed results, you're not getting those results. You get the tick box approach. Do you have slaves in your supply chain? Yes, no, no. Do you have children in your supply chain? Yes, no. No. It's like, okay, great. The infamous tick box approach. Those guarantees we know don't work. The companies know they don't work. That's not how they deal with things like quality control, time management, timely delivery. It's like, okay, what we need is monitoring and that sort of stuff. Again, bring to non-product values the supply chain management techniques they're using for product values. So why do they need effectiveness now? Well, there's reputational and ESG stuff. In some groups, that's like a big deal. People will talk about the value of the reputation of the company. It's huge. There are all these studies about it. And maybe that's true. As an academic, I have to say, they're rigorous studies. They appear to be true. I don't really believe it, but, I can't say that publicly. Customers really care. Yeah, maybe. So we have studies of this too. I was talking to my students about this earlier. If you look carefully at the studies, the ones that are done well, there's some conflicting results. A lot of them say consumers care, but if you look carefully, they don't care very much or the study is not well done. And we can get issues with customers, but when I talk to the businesses, a lot of the times privately, they'll say, yeah, it'll go away. And it does. So what matters more? Investors. And, that's where the money is, and that's what's driving things. And for a while, investors really cared about ESG. And I was actually surprised it wasn't more controversial than it was. And for there were a couple of years there, everybody was like on the ESG bandwagon. I was like, how is this going to last? Well, it didn't. So where we are with ESG now, I don't know. But it doesn't turn out to matter. And here's why. And so let's talk about business trends. So you do have the consumer boycott risk. You have the consumer litigation risk. I put consumer in quotes because it's really coming from the NGOs. But whatever, there is litigation risk. More importantly, there's financial risk because the lenders or investors can see their investment evaporate if there's the wrong kind of scandal. And everybody knows the stories. And so, on the investment side and the commercial lending side, whether we're talking about development banks or commercial banks, and whether we're talking about, the big syndicated loans, they care because this is not a compliance issue. This is an operational disruption issue. And that means no return on investment. And not poor return. It can mean poor return. It can mean zero return. So that is a huge piece, and that's, I think, one of the key drivers. I used to downplay the legal side of things and say, the really most important piece is what the boardroom cares about. And here's where it matters. Like the business law people, a lot of these are not the lawyers and the NGOs advocating to the boards. They're already in the boardroom, right? They sit on the board, or with the board, if they're the general counsel. So that's what matters. That's what drives things. But the legal trends do matter now. We started, thanks to the leadership of some here, with the UK and the disclosure laws. We then sort of took another step towards due diligence laws. And in the United States, we had, for a while, very little enforcement, but now we have skyrocketing enforcement starting under President Trump. And many people are very surprised at that. But once you realize it was part of his anti-China policy, it starts making sense. So what we have is we've had changes in our Tariff Act and UFLPA, the Uyghur Forced Labor Protection Act. We started having movement on that in sort of this, shall we say, fraught relationship between the U.S. and China with respect to trade and other matters. And then we had the move to the Biden administration, and there was less surprise there that there's all this investment in that. So we're getting goods being seized at the border at a rate that nobody had ever dreamed of a few years ago. So bottom line, that's why the companies actually need their policies to be effective now, the business side and the legal side. So yeah, there's the compliance piece. There's also the business piece. We've tried to make it work for businesses, but we've also tried in our second version to look not just at the buyers, the typically big Western buyers, but talk to suppliers all around the world, labor, unions, and so on. We talked to everybody we could think of. And because they had seen from our first version that it was having some traction, they did actually talk to us. And so we put that all into this second version of the model contract clauses. They are largely guided by the UN guiding principles and the OECD due diligence guidance. And those have a number of pieces. Human rights and the environment are tied together in those ways. And so we try to put that all in to the model contract clauses. We have made them modular. We realize not all companies are going to do all this all at once. I'm not even sure it's good to try. I am a big believer in baby steps. But the idea is that they should be an effective, practical tool. Some people still prefer the first version. It's still out there. There's a book we have called Contracts for Responsible and Sustainable Supply Chains. It makes great presents for the holidays. You could buy it for all your friends and family. And you can get all this stuff and it all in one package. Looking to the future, what we need to do is make this more effective and more practical. We're never going to get all the way there, but the key piece is going to be technological. A lot of supply chain management is technological now. The contracts, and from a legal standpoint, this is super interesting, like contracts to mesh with the machines and the systems engineering, and also to allow learning. And that's some of the most interesting, most challenging stuff. I don't think this is a tech audience, but there are tech folks in the room. The idea of machine learning based on automated mapping and tracking and those sorts of things, all kinds of really practical, effective things to be done there. That technology is tied to this much larger economic trend of vertical disintegration. We used to have companies that were vertically integrated that would make everything themselves. Now it's largely horizontal. They buy everything. And so what that means is what used to be management functions within a firm have shifted into contractual obligations. And from a legal and management, business and technological standpoint, that's an immense shift. But the bottom line here is we're trying to use contracts as an instrument of governance because we have a lack of effective non-contract law, and management. And the management piece is how we get it to be operationally likely and make the policies work. So I know there's time for Q&A. I will look forward to all of that. Thank you.
Thank you.